Okay, good morning class. So today we're going to start a very important topic which is known as rule of strict and absolute liability. All right. So in law of torts, there is a very important rule known as rule of strict and absolute liability. Now, please note that this is a very important topic. The reason is this will come for your CLAT examination. This will come for your judicial examination. All right. So this rule is very important in law of torts. Now, we all have a basic idea what is law of tort. Law of tort, in a very simple term, it is also known as a common law or a civil wrong. Isn't it? It's not a crime, but it is a civil wrong. So, under law of tort, we have rule of strict and absolute liability. So, today we are going to discuss and try to understand what is strict and absolute liability under law of torts. Alright? So, before we start, let us try to understand strict liability, the concept of strict liability or absolute liability. What does it mean? So, strict liability, also known as no fault liability, is the legal responsible for damage or injury even if the person found strictly liable was not at fault. So, normally what happens in law? In order to have a case or in order to be liable for something, a person has to commit some mistake or a crime, isn't it? If I slap a person, then I have committed something wrong. If I try to fraud a person, then I have committed something wrong, isn't it? But in strict liability, it is just the opposite. Even though my intention is not to harm anybody, always remember, even though my intentions are not to harm anyone or cause damage to anyone or anyone's property, but then also I'll be liable for what I have done. This is what the concept of strict liability is all about. Now let me support my explanation with a very interesting case. Now, when did this rule of strict and absolute liability emerge? The question is there. All right. So, as we all know, in India, before our country was ruled by British, isn't it? They were from outside our country, and every law applicable till today is still made by British, isn't it? So, what happened was, there was a very interesting case known as Ryland versus Fletcher. All right. So there was a very interesting case known as Relents versus Fletcher. Now, in this Ryland versus Fletcher, this case took place not in India but in United Kingdoms during 1868. During 1868, this case happened. Now, what was the case? It has been noted above that in Relents versus Fletcher in 1868, the House of the Lords, laid down the rule recognizing no fault liability. So, the liability recognized was strict liability, that is, even if the defendant was not negligent, or rather, even if the defendant did not intentionally cause the harm or he was careful, he could still be made liable under the rule. Now, in this Ryland versus Fletcher, the House of the Lord said that even the defendant had no fault. The defendant had no intention to cause harm to a plaintiff, but then also it was his liability to face the music or to face the consequences. Why? Because what happened in Ryland versus Fletcher was, the defendant got a reservoir conducted through independent contractors over his land for providing water to his mill. There were old disused shafts under the site of the reservoir, which the contractors failed to observe and so did not block them. When the water was filled in the reservoir, it burst through the shafts and flooded the plaintiff's coal mine on the adjoining land. The defendant did not know of the shafts and not been negligent, although the independent contractors had been. Even though the defendant had not been negligent, he was liable. So what happened in this case was, there was a mill, all right, of a plaintiff. All right, there was a mill of a plaintiff. This was his part of land, and over here there was a mining of the defendant. All right, so this was the mill of the plaintiff, and this was the mining place for the defendant. Now what happened in this case was, they do not have any dispute regarding the boundary. All right, this is Reliance property and this is Fletcher's property. All right, now what happened was, Fletcher hired some contractors in order to dig his mining field. All right, so he started digging, the contractor started digging his piece of land. In order to have a mining, obviously we have to dig, isn't it? So the contractors started digging the field of Fletcher's. All right, now when they were digging up, they forgot or they failed or they left some mining shaft. Now mining shafts are holes. All right, now if you start digging under the ground, you will create a hole, isn't it? Now what happened was, there was a hole. Now water started leaking from that hole or a shaft, mining shaft, and entered into Reliance property. All right, the contractors started digging up. Number 1 point. Number 2 point, they had made a hole or a shaft, and from that shaft the water started getting inside the property of Mr. Ryland. All right, now the moment the water started entering into Ryland's property, his property was disturbed or damaged. All right, so what happened was, now in strict liability, although Fletcher had no intentions, all right, Fletcher had no intention to destroy or to damage Reliance property. His intention was to dig a mining and to make profit out of that. But even though he had no intention to damage Reliance property, but then also there was a mining shaft, and from that mining shaft water started flowing towards Reliance property and his property was damaged. So what did the House of the Lord decided? Even though Fletcher had no intention to cause damage to Reliance property, then also he is liable for his mistake. So what happened was, Ryland filed a case against Fletcher. Now Ryland was plaintiff and Fletcher was a defendant. All right, so the plaintiff said, my property has been damaged due to Fletcher's mining and all the waters which entered into my property. And what Fletcher said was, no, I had no intention to damage Reliance property, but then also it was not my mistake, but my contractors had left that mining shaft just like that, and from there the water started entering into Reliance property. The defendant said, but what did the House of the Lord decided? They said that even though Fletcher had no intention to cause damage to Reliance property, even though he is liable for what he has done. So this is the reason why it is also called no fault liability, because he had no intention. Now another example in a local term, this is just an example, not a case. All right, there is a neighbor. All right, we all of us have a neighbor, isn't it? Now in hills we have to back cut and we have to make a house, isn't it? There is a stepwise type, isn't it? Now this is just an example to make you understand. All right, now supposing this is Mr. A's house. All right, this is the house of Mr. A. Now what he has decided that he will make a water reservoir in his property. This is his property. This is Mr. A's house. This is his property. He has decided to make a water reservoir of his own for his personal use, a tanky in a local term. Now just below his property there is Mr. B's property. All right, so it has been, this is the boundary. Now they are chimiki, they are neighbors, they share the same boundary. All right, they don't have any dispute regarding property, regarding the boundaries, but Mr. A has decided to make a water reservoir in his property. Now when he makes a water reservoir, then if the water starts seeping and enters into Mr. B's property, now that is not intentionally, he has not made this reservoir so that this water reservoir will damage someone's property. This water reservoir is for his own personal interest, isn't it? But even though if water starts leaking and enters into Mr. B's property and cause damage, a small landslide, for example, a small landslide. All right, because of leakage of water from Mr. A's water reservoir, there is a small landslide. Then what happened? What will happen? According to rule of strict and absolute liability, Mr. A will be responsible for the damage caused to Mr. B's property according to rule of strict liability. Did you get it? So this is what rule of strict liability is all about. Even though Mr. A has no intention, he has no fault, but then also he will be liable for the damage caused at Mr. B's property. Now let us continue. Now in order to have a strict liability according to Ryland versus Fletcher case, there has to be some points or ingredients so that the defendant will be liable. All right, number one thing is dangerous thing. In Ryland versus Fletcher's case, in order to have a rule of strict liability, there must be some ingredients. So number one point is dangerous thing. Now what do you mean by dangerous thing? According to this rule, the liability for the escape of a thing from one's land arises provided the things collected as dangerous thing, that is, a thing likely to mischief if it escapes. Now, what happened in Relents versus Fletcher's case? There was a mining and one had a mill and another had a mining business, isn't it? For mining business, we have to dig the earth. Now, water had escaped and it entered to Relents property, isn't it? So that water is a dangerous thing. All right. In example which I gave you, that reservoir wala, if water escapes from my reservoir, from my property or Mr. A's property and enters into Mr. B's property, that water will create a problem, isn't it? It will create a problem. So that water can be a dangerous thing. Now similarly, if a factory, there is a factory Now, every factory has to follow some guidelines, isn't it? If a factory is about related to chemical things, now there has to be a proper discharge, isn't it? All the waste from that factory, it has to be in a proper discharged manner, isn't it? Now that becomes a dangerous thing. So it has to, number one rule for a Ryland versus Fletcher is there has to be a dangerous thing. Number two is non-natural use of land. Now, what is non-natural use of land? Water collected in the reservoir is such a huge quantity in Ryland versus Fletcher was held to be non-natural use of land. Now, if I make a huge pond in my property and if water starts getting leaked, then it's a non-natural use of land, isn't it? If I make a big water reservoir just like Delo, I'm sure you must have seen how big it is, isn't it? Now if I started making that kind of water reservoir in my property, although it is inside my property, my intention is not to harm anyone, my intention is not to cause damage to anyone, but then also if I make such a huge water reservoir and if it leaks and cause damage to someone's property, then it is non-natural use of land. Okay, now another one is escape. So there has to be an escape of that water. Now without escape, nothing can't be damaged. If there was no escape of water from Fletcher's mill and entered into Reliance property, then there would have been no damage, isn't it? So there has to be escape. All right, something has to be escaped. All right, that's the number two. These are the 3 points which we must remember. So number one rule is dangerous thing. Anything which will cause damage unintentionally, it has to be a dangerous thing. In a simple word, it has to damage something. All right. Number 2 point is non-natural use of land. The land in which something is constructed which is out of plan, or if it's a dangerous thing, then there has to be a non-use of natural land. And the 3rd point is escape. That dangerous thing which has been built in a non-natural use of land must escape. So these are the main 3 rules. And if these 3 rules are complete, then there will be a strict liability against the defendant. All right. So moving on to next is exception of the rule. Now this is also important. It's not that every time the defendant will cause damage unintentionally. All right. So there are exceptions also. All right, in this rule. Now what are the exceptions of this rule? So number 1 is act of God. Number 1 is act of God. I'm sure you must have watched that Akshay Kumar ko movie where this is applied. Now what is act of God? These are the exceptions in Relents versus Fletcher or rule of strict liability. All right. Now what is act of God? Act of God in a very simple manner is something which is naturally caused. Now for example, if there is a reservoir, all right, now that reservoir has caused damage to someone's property, but not due to leakage, natural leakage, but due to act of God. Act of God is if there is a major earthquake. If there is a major earthquake and due to that reason that water has escaped. Now that is an act of God because no one can stop earthquake, isn't it? Similarly, if there is a tsunami and causes damage to someone's property, now that is also act of God, isn't it? No one can stop it. So this is act of God. This is one of the exception. Now another one is consent of the plaintiff. Now if I make a reservoir and I have asked my neighbor, all right, that I am making a reservoir, do you have any problem? And we can share water from this reservoir. Now I have informed him and he has also said, okay, you can make a reservoir, there is no problem. So there is a consent from the plaintiff. So in future, he can't say that because of the escape of the dangerous thing, that water, my property has been damaged, because he has already given his consent. Alright, so second exception is, the exception is consent of the plaintiff. Now the third one is act of third party. Now again, if I have a reservoir and the third party comes and destroys my reservoir and the water escapes, then there is an act of third party, isn't it? I had no intention, my water reservoir was well built, well protected, but someone else came and he destroyed. So act of third party. And the fourth one is plaintiff's own fault. Now plaintiff's own fault is, supposing this is a water reservoir in my property and this is Mr. B's property. Alright, now he knows that I have a water reservoir and his house is just below my water reservoir. If he starts digging out here, then obviously my water will escape, isn't it, from my reservoir? So that is plaintiff's own default. Alright, so these are the exceptions of the rule. First is, there are three rules that has to be there, or we can also say there has to be three ingredients so that this concept of strict liability will be fulfilled. And the second part is exceptions. Alright, if these exceptions are there, then the defendant won't be liable. Alright, but if the rules are fulfilled, then the defendant will be liable, even though he has no fault, he has no intention to destroy someone's property. Alright, so this is what strict liability is all about. Now moving on to next is, what is absolute liability then? Now for this, I would like to tell you that please log into Google and just search a very interesting case called MC Mehta versus Union of India. Alright, again, MC Mehta versus Union of India. Now what happened was, in absolute liability, what happened was, there was two incidents which took place in India. Alright, the first case was, there was a leakage of oleum gas on 4th and 6th December 1985. So there was a factory in Delhi, and over there was a leakage of oleum. There was a leakage of oleum gas. Alright, now we all know in rule of strict liability there has to be a dangerous thing. This oleum gas was a dangerous thing, and there has to be a escape. Now this oleum gas escaped. There was a leakage. Now what happened? What was the consequences? And this was owned by Shriram Food and Fertilizers Industries. Alright, so there was this factory was a Shriram Food and Fertilizer factory. Alright, from there this oleum gas started leaking, and in Delhi many people died because of this incident. Now another one was Bobal Gas Tragedy. We all have known or heard about Bobal Gas Leakage. What happened in this was, there was a gas plant in Bhopal, alright, and at night when people were sleeping, there was a huge leakage of gas which killed many people. Alright, now when these things happened, now who was liable? There has to be some person who has to be liable for this loss of property, loss of lives. Alright, so because of that, absolute liability was introduced, so that in future, whenever there is a factory, and that factory has a dangerous thing. For example, in fertilizer factories where the fertilizers are made, now these factories are very hazardous in nature. There are many chemicals which are very harmful, not only to humans but also to the environment. Now, someone has to control it, isn't it? So in order to control that, the rule of absolute liability was introduced. So in today's time, in a very general manner, absolute liability is for factories especially, so that any dangerous things will not escape, and if it does, then that factory owner will be liable for his mistake, even though he has no intention to kill people by leaking all those kind of dangerous toxic gases. But then also, if it escapes, if those dangerous things like oleum gas escapes and it kills or it affects the health of a human being or an environment or someone's property, then the owner of this factory will be liable, even though he has not done any mistake. Now, there are also exceptions for this rule. So the only exception is that there has to be person involved. There has to be a person or a factory involved, and if the third person is involved, only then this owner will not be liable for what damage he has or his company has caused. All right. So absolute liability, I will read it out. If an industry or enterprise is engaged in some dangerous activity which activity is capable of causing catastrophic damage, then the industry officials are absolutely liable to pay compensation to injured party. All right. So this is what I have all explained. Now the principles of absolute liabilities are: dangerous thing, non-natural, there has to be a dangerous thing. For example, this oleum gas was a dangerous thing which caused death in Delhi. Escape is not necessary. Now, in this, escape is not necessary. That is, if there is no escape of any dangerous thing, then also result of absolute liability will be applied. So, even if the gas is not escaped, but the workers over here working are harmed due to this dangerous thing, then also the whole liability, the absolute liability will be to the owner or the entrepreneurs of that company. All right. And the third one is, there is no exception for absolute liability. So we should always remember that in strict liability there are exceptions like act of God, plaintiff's own fault, isn't it? Now in absolute liability there are no exceptions. The company can't say that, oh, my oleum gas escaped because of act of God. There was a major earthquake and because of that my gas escaped and this happened. No, the company can't say. All right. So this is what the rule of strict and absolute liability is all about. So in the next class we will start again with law of contract. All right. So this is very important. So please, if you don't understand, please call me, WhatsApp me. All right. Thank you.